Yeah. Good morning. Committee going to bring the meeting to order. Members, thank you for being here today. I know this is the only thing between you and going home, so we're going to try to be good about that. Staff, thank you very much for being here. Conferees, thank you very much for being here today. And we're not going to mess around. I'm going to go ahead and open the hearing on Senate Bill 29. Carly is going to give us an overview very quickly. Thank you, Carly.
Thank you, Mr. Chair. Good afternoon, committee. Senate substitute for Senate Bill 29 removes the authority of the county or joint board of health or local health officer to prohibit public gatherings when necessary for the control of infectious or contagious disease. Section 1 amends 65-119 to remove such authority. A county joint board of health or local health officer would be permitted to recommend against such public gatherings. The bill passed the Senate by a vote of 28-12, and it would go into effect on July 1st, 2025, upon publication in the statute book.
Committee questions? Seeing none, you must have done a great job of explaining that to us. Okay, I'm going to back up here just for a minute. Representative Bueller has some folks visiting from his district. And so if you would all stand. Very good.
Thank you, Mr. Chair. That is the Leadership Leavenworth Lansing class sponsored by our Chamber of Commerce, and I'm glad to see they took up half the conference room. Thank you, Mr. Chair.
Very good. Welcome to committee. Okay, with that, the first proponent we have is Tiffany Ellison. Tiffany? Welcome to committee.
Thank you, committee members, for having me today. I think this will work if I let it go. Thank you so much. You have my written testimony, and I do stand in support of amendments to Chapter 65 that would take into account scientific reasoning and also constitutional protections for citizens. Everyone wants to keep themselves and everyone else healthy, but we also want to make sure that we're doing that within the bounds of the constitutional protections, the individual liberties to determine our own health and wellness. I am a health and wellness professional. I work in the health and wellness industry. But you have my written testimony, and if it would please the chair, would it be okay if I donated the rest of my time to one of the other conferees today, one of the other proponents?
Yeah, that's fine.
Okay.
Thank you.
Thank you very much.
Just hang on just a second.
Who?
No, well, not necessarily, but committee questions. Seeing none, thank you.
Thank you so much. Appreciate it.
Okay, next we have Jacqueline. Welcome to committee.
Thank you. Thank you, Chair. Thank you, distinguished members of the committee, for the opportunity to speak about this very important issue. My name is Jacqueline Paletta. I live in rural Miami County. I'm also an attorney. And right now, as we speak, I represent a family from Bueller, Kansas, whose daughter was allegedly exposed to a suspected case of chickenpox. And as a result of that alleged exposure, she was excluded from her high school for 21 days. This child has remained healthy the entire time, has not developed any symptoms of chickenpox. She's an honor student who has never been in trouble of any kind. And yet she feels like she was punished simply for the crime of not being vaccinated against chickenpox. On February the 14th, the school called her mother to tell her that she would not be permitted to return to the school until March 5th, and that the health department would be calling to explain such things to her. Not until February 20th did she have an opportunity to speak to the health department, who told her that her daughter was allegedly exposed to this dangerous virus on February 11th, 9 days prior. And only if she would be vaccinated within 72 hours of that exposure, then she would not be excluded from the school. Well, more than 72 hours had elapsed. And so that was not an option, never mind her right to choose against that. As a result, we sent a cease and desist letter to the health department in Reno County and to USD 313. Thereafter, Reno County Health Department wrote a quarantine order and sent that to Harvey County for them to issue to this family. We filed suit on Monday in Harvey County against all of those defendants. The judge found that that order out of Harvey County was unlawful, and he struck that order. Nevertheless, the judge indicated that we need to have further briefing on this issue. We asked for declaratory relief. The judge indicated that the legislative intent is unclear because Section 122 allows schools the opportunity to exclude folks that do have a virus, that are afflicted or affected with a virus. But because that Section 122 doesn't have any rights to redress and doesn't have any probable cause, the judge said that the legislative intent was unclear. So I'm here as a proponent of Sub-Senate Bill 29, but it doesn't go quite far enough. This is a great first step. I think that there are a couple minor tweaks or revisions or additions that would make this even more effective for your constituents. Some of you may believe that perhaps these ideas of exclusion, isolation, and quarantine died with COVID-19, and I stand before you letting you know that that's not the case. The reason why I believe that the revisions to 65-119 don't go far enough is because, like what happened in my situation with my client, KDHE can simply rely on a different provision of Chapter 65, one which does not allow for redress, which does not require probable cause. KDHE created rules that the school understood to be necessary because you see in Section 65-101, it indicates that KDHE has the authority to make regulations to enforce the public health. And that's exactly what happened here. KDHE created something called the Varicella Investigation Guideline, which dictated that the school should exclude anyone who was allegedly exposed to any type of virus. See, my problem with this situation is that we have delegated non-delegable authority to KDHE, which is non-elected personnel who don't get voted on, to create laws and then simultaneously enforce those laws. So they sit in the position of legislature and judiciary, not affording our constituents the opportunity for redress should they be aggrieved by any of the behaviors that happen in these circumstances. I too believe that we need a public health to help us keep us safe, especially when there are viruses that are new or novel, when there are recommendations or guidelines, education that can be provided. However, these cannot be had at the expense of the liberties. The Kansas Constitution affords us the opportunity to have substantive and procedural due process. These are not embodied in Chapter 65. They are in certain chapters, such as 129C, such as 201, but we need that potential for redress to be applicable to all of the sections of Chapter 65. Imagine a situation where it's very, very dangerous. There's a serial rapist that's on the loose, and the police know exactly who that person is. And so right now, this person stands accused of being a serial rapist, and arguably that is an emergent community interest where the community would be safer if only that person were in jail. Can the police simply go to that person's home, arrest them, and throw them in jail and throw away the key? No, they cannot. They have to write a probable cause affidavit. They have to verify that with an oath. They have to get that signed by a judge. And then within hours of that arrest, that person who's accused of that crime is entitled to an arraignment. And thereafter, they're entitled to a probable cause hearing, only to later determine their fate by a jury or a judge. We don't have any such protections for this healthy honors student from Buhler, Kansas. KDHE, the school that received that delegated authority from KDHE, can just sort of arbitrarily say this child is a danger. It doesn't have to be verified by anybody. It doesn't have to be signed by a judge, and that child can be remanded to their home. This has to change. I have never been a part of the legislative process before, but I am a litigator, and showing up in court, I thought that the judge would be able to provide redress for this. And when he indicated that the legislative intent is unclear, that is why I stand before you today. This is a very important bill, and we have the opportunity to preserve both the authority that KDHE has to make recommendations and guidelines, but also protecting our liberties at the same time. So I ask for your consideration for this bill. I will stand for questions at the appropriate time.
Very good, Jacqueline. Questions? Representative Bryce.
Thank you, Mr. Chairman, and thank you, Jacqueline. I appreciate your passion on the subject. I was just curious. I'm trying to understand your position on the individual rights versus public health problem that we come across. Are you proposing that individual rights should never be superseded by public health interests? For instance, if there's a deadly virus, are you saying that public health concerns with the deadly virus cannot supersede individuals' rights to mingle and associate? Just clearing that up for me. Thank you.
Thank you. I am suggesting that to the extent that we are going to infringe on individual liberties, such as the freedom of movement or where someone can go, excluding, isolating, quarantining those individuals, that has to be met with probable cause. So the same way that probable cause is required in other situations where we restrict folks, then it should similarly be in this context as well.
Just a quick follow-up. I appreciate that. Your analogy with probable cause, I think from the public health point of view, that would be exposure to a potential, if there's documented exposure to, for instance, I was working in emergency rooms when Ebola came through, and if you were, the probable cause analogy, I think, would be documentation of exposure. Am I correct in that?
So not only documentation of exposure, but verified by oath. So the Kansas Constitution Bill of Rights, Section 15, says that no action shall be taken but on probable cause supported by oath or affirmation. And so the probable cause could be documentation of exposure of a confirmed case, documentation of that exposure, and then the oath or the affirmation would affirm that that is in fact a danger to the public health, such that infringement on those liberties is the appropriate step.
I'm sorry, one more thing. But so for your analogy with probable cause and versus public health, a doctor or healthcare professional affidavit or oath that a person has been exposed to this deadly disease, that would be adequate for probable cause to have public health officials be able to quarantine or confine the person?
Subject to redress. So if they can have the documentary evidence to show that a person was exposed to a confirmed case of a dangerous or potentially life-threatening disease, and that's affirmed by an oath that exposure would put the public health at risk, then they can take the steps allowed in the statute subject to the right to redress, which means that the individual would have the right to an appeal to a district court judge within 72 hours of their exclusion or their rights being infringed upon.
Okay, thank you very much. Thank you, Mr. Chair. I think that's a very important dichotomy between personal liberties and public health. Thank you.
Representative Blex.
Thank you, Mr. Chair. This bill, as it's written, as I read it, would remove the authorization of a county or a joint board of health or a local health officer to prohibit public gatherings. And I might ask if permission if I get the revisor to define public gatherings, but do you see any control at a point that we know an infection is there? How would you recommend dealing? Because we're going to remove all authority, that looks like under this bill. And then I read the supplemental note, and it kind of indicated that it'd be recommended county health officer and recommended to Board of Commissioners. But this bill says I'm not going to have anybody. You don't want any restrictions? Am I interpreting that correctly?
So respectfully, my understanding is that the revision to 119 changes the word from prohibit to recommend, such that the county Board of Health, the county commissioners who sit as the Board of Health, can determine whether such a recommendation is going to be implemented in their community. As we saw during COVID-19, different communities wanted to handle the situation differently. And so I think the idea behind it was to allow them to recommend as opposed to declare and prohibit.
I appreciate it, Mr. Another, because that changes the whole perspective for me, because the bill says it's actually removing all pretty well authority from anybody, but your interpretation is that that the county health officer or somebody would recommend to the county rather than shall.
That's correct.
Maybe the revisor I apologize, I must have been sleeping when you read that first part. I missed that.
Mr. Chair, Representative.
Carly,
Yeah.
do you need some time?
I do need a little bit of time.
Let me go on to
I
Representative
appreciate
Droege. And
Thank you, Mr. Chair.
Very good. Representative Droege.
Thank you, Mr. Chair. Thank you, Jacqueline. One thing I think I wanted to mention here is if the committee has looked at the original Senate Bill 29, and then what the Senate did to it was just totally gutted it, and it just came out with a 3/4 of a page bill. And so the original bill had a lot more concentrated control in it. But this bill, what came out of the Senate then really has not much in it. But what we're talking about is we need to do something with that bill to make it a positive direction in the healthcare system, so that people that are exposed or supposedly exposed to a virus have some redress, so that they can go on and they aren't just told over the telephone, you got to stay home for 21 days. They're told who says it, why it's said, and how they can go and talk to somebody within 72 hours to get some redress. Because in the case that Jacqueline was talking about, the chicken pox was never even
Confirmed.
proved. It was just supposed. I mean, it was never a confirmed case. So this girl lost 21 days out of her school career without any way to go back and get help. So truthfully, as I looked at this bill, I thought that it was so completely gutted it wasn't hardly worth wadding up and throwing in the trash. But by taking the bill that came from the Senate and adding an amendment, we can go in a positive direction for the health and future of our state.
Thank you for that, Carly. Let me know when you have time. Are you good?
Yes.
Okay.
As the bill is written, the entities listed in this bill cannot prohibit public gatherings. They can only recommend that you don't hold public gatherings. And to go further, the term public gatherings is not defined. We've looked for it in statute and cannot find a definition in statute.
Thank you for that. Thank you, Mr. Chair.
Representative Bueller.
Thank you, Mr. Chair. So Jacqueline, you had mentioned that you thought the bill in its current state was lacking in, I think in your testimony, I don't remember the exact words, it was lacking in some context. Could you at least provide some thought context or some explanation of what you think would I guess, enhance the bill? Thank you.
Thank you. The Kansas Bill of Rights Section 18, all persons for injuries suffered in person, reputation, or property shall have remedy by due course of law and justice administered without delay. And so I'm suggesting that we add this opportunity for a person who is excluded, isolated, or quarantined to have the opportunity to appeal to a judge, to say, Judge, I don't think that I'm a danger, can you please let me out of jail, basically? Can you let me go about my life, return to school, that sort of a thing. And then at that point, the health department would have the opportunity to prove to a judge that it's in the interest of the community to keep that person quarantined or excluded or isolated.
Okay. Thank you, Jacqueline. Thank you, Mr. Chair.
Representative Droege.
I think that this boils down to, thank you, Mr. Chairman. I think this boils down to where you have, the legislature makes a law, but then you have all these agencies interpreting the law, and to allow an agency to just interpret the law and confine someone for 21 days, first of all, I don't think it's fair or legal in the first place because nobody gave them the right to do that. And secondly, to not be able to know exactly what was going on, how you were exposed, and not have any way to redress is, I don't think it's the way we ought to be.
Thank you for that. Committee. Representative Steens.
Thank you, Mr. Chair, and I apologize for arriving a little late, so I didn't hear the story about the chicken pox. I was just reading about that. I will say, I think that is a big problem with the KDHE and some of the, and I'm not just picking on them, I'm just mentioning them because we're here discussing it, but when I myself worked in healthcare and I saw a lot of problems with COVID, you would go in one facility, assisted living, and they would have one policy, and then you would go to another entity and they would have a different policy. And so it was almost as if people were just writing policies on napkins and deciding what, okay, this person has to isolate for 5 days, this person has to isolate for 12 days, but there was really no uniform policy. And so I don't know exactly how that boils down either as far as how we look at that because I'm not saying I want to be reckless either and just have people making up things. And I want our public officials and our doctors and people to have say into things. But I do think that is a problem. And there were a lot of people who didn't know what the rules were. People were getting upset. People were being kicked out of facilities if they didn't obey. And a lot of these were seniors and people who didn't know recourse and how to handle that. So I do think this arose. And I don't know this chickenpox situation. I didn't even know you had to quarantine. I mean, so I apologize. That's all news to me in this case. So thank you. I'm not sure if you can answer any of those questions or if that was really a question. Part of that was some of a statement too. Thank you.
Thank you, Representative. Actually with me today is the mother whose daughter was excluded from school for those 21 days, and she has submitted her written testimony as well. As it pertains to those regulations, again, the Kansas Constitution Bill of Rights, Section 20, states as follows: the enumeration of rights shall not be construed to impair or deny any others retained by the people, and the powers not herein delegated remain with the people. And the thing is that Section 65, 101, it allows KDHE to take action to prevent the introduction of infectious or contagious diseases. And then it goes on to say, may adopt rules and regulations necessary for that. And so, for example, in this case, the varicella investigation guidelines, they define outbreak two ways. One is an outbreak is greater than or equal to 5 cases. And in the same guideline, it says an outbreak is greater than or equal to 1 case. So which is it? An outbreak is 5 or an outbreak is 1. So when we've delegated legislative authority to KDHE and then we've also authorized them to order the sheriff to execute such an order, then we're allowing them to sit in the position of a judiciary as well without affording a person the opportunity for probable cause to demonstrate, I really am a danger to community such that my rights need to be restricted and I need to stay at home. And to the extent that it would be argued that it's impractical or not feasible, I think that the criminal case is a perfect example. This is not happening all the time. If it were, your constituents would be calling you. So to the extent that we have to take the extraordinary step of excluding an honors, healthy high school student from school for 21 days, then that should also be met with a minimal requirement of a demonstration of probable cause and the right for that person to seek the court's assistance if they were wrongfully quarantined, isolated, or excluded.
Very good. Thank you. Committee, further discussion. Representative Howell.
Thank you, Chair. Thank you so much for testifying today. Did you testify in the Senate?
I did not.
Okay. And do you happen to know what committee this was heard in?
I
in
do
the
not.
Senate? In public health? Okay, thank you.
If I could just say that what happened in my situation, why I'm here today, is because when this happened to my client, I called my representatives. I called my senators to say, hey, did you all know that this was happening? And so they put me in touch with Representative Droege, with some of the other representatives, and said, hey, by the way, we're hearing something about this. Could you come and share your experience? Because our colleagues don't understand that this is something that is ongoing even after coronavirus's history.
Representative Bueller.
Thank you, Mr. Chair. And I don't know what the amended language would be, but I'm sitting here thinking of a year ago in this committee when we were talking about access to nursing homes and some of the overreach that happened during COVID. And we walked back, Dr. Epley was still in, and we walked back some of those, what we were planning to be restrictions or I guess the ability for people to have more rights in situations like that. And I think the general consensus was, okay, we're far enough away from COVID that this isn't happening anymore. So to me, this is an example of an alleged case of chickenpox, and it's still happening. So I would be interested in whatever the amended language is, and for this committee to see that. And I don't know if that's my colleague to my left or working with Jacqueline to do that, but I would like to see some amended language that we could revisit this bill with at some point in the future, because this should not be happening. I fully realize KDHE's obligation and responsibility to public health, but it can't be at the extinguishment of individual liberties and rights. So that would be my request. Thank you, Mr. Chair.
Thank you for that. Representative Reeves.
I think you mentioned 65-122, Kansas statute.
Yes, yes, yes,
Okay.
ma'am.
Can you repeat what you had said about that statute? I've got it in front of me right now.
So that statute affords the school, a principal, or a parent. It says shall exclude a person that's afflicted or affected with a contagious virus or disease. But because afflicted and affected aren't defined, I think that it's clear, but the judge interpreted that to mean that affected could mean contact as opposed to simply afflicted with the actual disease, and used the word shall, granting the school the authority even in the absence of probable cause, because probable cause or any type of affirming characteristics are not listed in that particular provision.
Thank you, Mr. Chair. What I like about the language in 65-122 is that it does give it says the duty of, use the word duty of the parent, private school, duty of the parent or guardian and the principal or other person in charge. And I would hope that it would be a joint decision, whether the child was exposed enough that that she would need to go through the 21 day. And I'm assuming that the 21 days is because that's the protocol when you're exposed to chickenpox versus something else. I don't know. So 21 day isn't, I don't think, don't think it's a blanket, you're going to always be out for 21 days. According to the statute, it really depends on what the exposure is that the person might have been exposed to. So, I think that's a guardrail right there into this. No, I think what happened is pretty mixed up, but there was a judge involved to interpret the statute. So, I don't know with the next judge how they might have interpreted the statute, but we've got to rely on our courts to do that for us. So
in response to that, so since it says shall exclude, it doesn't actually give any sort of option and doesn't provide any sort of documentation about the exposure. It also doesn't allow any type of redress or appeal to a court. And so I appealed to the judge under section 65-129C, which does allow an opportunity, but that was in regards to the order that came out of Harvey County. And so what I'm proposing that we do is we allow that opportunity to be heard by a court, by a judge within 72 hours, as is indicated in section 201, as is indicated in section 129C, that if a school or if a workplace, if they decide that they're excluding someone, they likewise have that opportunity within 72 hours to appeal to a court to determine whether there was probable cause or sufficient evidence for the sake of the community to exclude them.
And I'm following you all along, and thank you, because it's very clear what you're trying to say. So what happens to the child during those 2 72-hour, potentially 2 72-hour periods?
Okay, so this was the issue in this particular case, was that they were verbally told, you can't come back to school until March 5th. And that was already on February 14th, which was after February 11th.
I'm sorry, in the new case, in what you're proposing now, within those, 72 hours, and so there could be 2 periods of 72 hours, correct?
No, so what would happen is as soon as someone is excluded, then they have the opportunity to be heard by a judge within 72 hours of petitioning the court for such a hearing. So what happens is the school says you're excluded for 21 days. Then immediately that individual can appeal to a court like they can pursuant to 201 or to 129C, and the court shall hear them within 72 hours to make a determination as to whether they shall be excluded from their school or whatever, or quarantined or isolated, or whether there's not enough evidence to do that and they can return to their normal life.
Great. Thank you.
Committee further discussion. Representative Howell.
Thank you, Chair. Just a couple of quick comments, if I may. One is I am not a medical expert, so I will just say that up front. And I know there are some here on this committee, but I will just say as the mother of 5 children who all had the chickenpox, and I was an adult when I had the chickenpox, the incubation period is 21 days. So that is the reason for the 21-day quarantine. And so if you did actually have an exposure, then you would need to have a 21-day quarantine. So, but I would just like to suggest that I think there is some reason for concern that this conferee has brought up, but perhaps this might be something that we might want to consider, that this should be heard by the judiciary, because this is dealing with law or other parts of the law, and is getting into some interesting areas that aren't just health, perhaps. So it's just an idea and a suggestion. So thank you.
Thank you for that. Representative Bryce.
Thank you, Mr. Chair, and thank you, Representative. I'm listening, and of course, everything we do has to do with the law, but when we're saying we appeal to a judge within 72 hours, in my mind, I'm thinking the judge doesn't know any more about chickenpox than the principal does. And so I'm not sure the decision maker that would be best would be a judge. And maybe this relates to the representative's question. It really, in my mind, ought to be a medical professional that signs, that gives an oath or a form, affirms, you know, depending on the disease, the quarantine time, et cetera. If you go to a judge, I'm just not sure that would be the right recourse, but those are just some thoughts. Thank you.
Chairman, may I please respond to that?
You may.
So the reason for that recommendation as it pertains to Senate Bill 29 is because that's already contained within 129C and 201. So the legislature of this state has already determined that a judge is the one who should determine whether or not an individual's liberties should be restricted. That balancing act of the substantial government need or the community interest is weighed against the liberties of the individual. And so that is why a judge sits in that place to respond to that.
Representative Bryce.
Thank you, Mr. Chairman. And if I could just respond to that, we're not just dealing with individual. I am 100% for individual liberties. I'm Mr. Individual Liberties, but at the same time, we're dealing with, even though COVID is not a good example, the COVID response, potential public health problems that it's not just weighing whether the individual has rights or not, it's weighing whether there's a public health issue, a medical issue, and I'm not sure that half of the equation is best decided at a court of law. I guess that's what I'm saying. Thank you.
Committee further discussion. Representative Droege.
Thank you, Mr. Chairman. I understand where you're going, Representative. But if you don't give someone redress some way, I mean, so you get to go to the judge and judge, well, I don't know enough to decide this. Well, then you'd call a doctor in, but at least they have some direction to go instead of an executive decision that puts them in timeout for 21 days. And I know that you're a believer in personal liberties, and I tend to lean in favor of personal liberty. And I also wanted to let people know that we've got some things with the reviser, and we're going to try to bring something to revise this bill next week.
Thank you for that. Representative Weigel.
Thank you, Mr. Chairman. So sitting here listening to the conversation, I just want to play out this idea a little bit of the 72-hour go before a judge. Let's play that out, that the judge says, you know, it's fine, they can go back to doing whatever they were doing, but they were in fact exposed, they are in fact contagious. What responsibility do you think all the parties involved in this have to notify everybody else in those settings? Like, I'm thinking, you know, there's measles outbreaks in the country. Young children under the age of 1 are not vaccinated for measles. So if this is like a child care situation and a judge says, oh, they can go back to that child care, is there a responsibility to notify every single family that's in that child care that there is a child there that has potentially been exposed to measles?
Thank you for your question. So as happened in our case, the local health department and the school district were able to put on evidence for the court. So they brought the documentation to the court for the court to consider the whole entire picture. And so the same way that when an accused criminal is released and not put in jail, we don't notify the entire community that that person's not actually a sex offender, not actually convicted of a crime. That's what the judicial process is all about.
Thank you, Mr. Chairman. But I guess, I mean, what is your opinion is that nobody else needs to be notified. If a child is given the okay by a judge to re-enter school, church settings, community settings, grocery stores, even though they have potentially been exposed to a disease, there's no obligation. Let's just use childcare or school because that's where, kids are going every day. That's where they're required to go every day, right? Unless they're sick. So you don't think there's any responsibility that other families that are at those locations would need to know that?
No, if we're talking about an alleged exposure to a suspected case, so even the original case was not confirmed, and now this person is not sick, doesn't have any symptoms, if that person later develops some sort of contagious disease that's reportable, that would be reported and the contact tracing steps would then ensue thereafter. We're not going to assume that people are sick when they're not, and that is the piece that I'm advocating for, that there has to be something other than we believe someone may have been exposed to something and then restricting their liberties without any sort of due process.
Thank you, Mr. Chair. But what happens in the situation where where there is proof that somebody has been exposed, that there is an original case, but the judge still says you can go back and supersedes the authority of the medical expertise in the county health department? What's the responsibility then to others?
So that is why the government works, is the checks and balances. So we have a legislature and we have a judiciary and we have an executive branch that balance each other out. That shouldn't be stripped away in the name of public health.
Committee further discussion. I do, like Vice Chair Bryce says, I do have a little bit of concern about a judge deciding this when they have about as much medical experience as I do, which is zero, except sometimes I get sick. So I don't know what would be a better person to decide that than a judge that has no medical experience, though I'm not arguing about the appeals process or anything like that, but I do have some concern about a judge with no medical experience deciding that. What would be your answer to that?
The same way that the judges aren't familiar with, for example, a custody situation and the intimate relationships between those family members and who should be better to have custody of children or who should be better to dictate where the children should go to school. The judge hears the evidence and then makes the determination from there. And so the judge isn't in everybody's home. He's not a medical doctor. He's not an engineer. How many cases does the judge have to hear that aren't within his specific realm of knowledge, but he has the law to balance it against with the facts. So he has the law to balance against the facts, and the parties, so the public health, whoever is representing the public health, has the opportunity to present their evidence, and the family has the opportunity to present their evidence. But as it works in the statute for 201, as well as 129C, the child has already expressed that their rights have been infringed. And as long as they can demonstrate that there has been a threat to the public health, then that order or that recommendation would be honored by the court. So just because he doesn't have the medical knowledge, judges also don't possess trademark or secret sauce knowledge, but they take the facts that they're given in that particular case and they weigh it against the law to make a determination based on the evidence that's presented to them. So either the government presents a compelling case or they don't.
Very good. Thank you for that. Representative Blex.
Thank you, Mr. Chair. And I think we're all still reeling from the effects of COVID to where, why in the world do you quarantine healthy people? And that's still sticking in our craw. We've seen nursing homes issues like Representative Buehler brought up, but we had to back up a little bit because of funding. But our thought process is that it went too far and it went way far above our rights. And knowledge isn't necessarily the curriculum here, I guess. Supreme Court decides how much funding schools get. That's supposedly the legislator's job, and a lot of them. And people come to me to introduce a bill that I know nothing about, and yet I make a decision and get it through. So we have that problem all over. I don't know of any other system under the rule of law that would probably be better than a judge, even though they may not have the medical knowledge. But I think everybody is really concerned, myself included, about the freedom that we have lost and the fact that we have 21 days, in this case, of that young lady's life has been altered for no apparent reason. I'm a wildlife biologist by training. I understand a little bit, but I also treat my cows with herd immunity, and they got over it. And, not that I'm against vaccination. Vaccination is important, but I think we're sometimes stepping too far. Thank you, Mr. Chair.
Any further discussion? Now you guys can see why I love these kind of bills. Thank you very much for that.
Thank you, Chairman. Oh.
One more.
Oh, Representative Bergquist.
The previous representative mentioned COVID, and it was a big, massive event for the whole world. This is one isolated incident which just re-exposes that problem, the same problem. And to me, it's the same problem. And a careless, seemingly, I'm not the judge, but a careless handling of a situation that left a person without any redress and without any apparent care because it wasn't their problem. Somebody overlooked something, and somebody tried to do something about it. And we appreciate you being here. Thank you.
Thank you. And also, I just would like to say in response to that we're not talking about quarantining sick people or excluding or isolating the sick people. We're talking about perfectly healthy people that, in this case, probably weren't actually exposed because the case wasn't even confirmed. So that's why it's really important that we're taking a look at the whole picture.
Representative Bryce.
Thank you, Mr. Chair. Thank you again, ma'am. Something you just said triggered something with me because as we said before, there is a need for redress, obviously, and we need to work on that. But this thing that a judge can decide these medically oriented issues, I think is very short-sighted. What you just said was we're not quarantining just sick people, we're quarantining people who are healthy. Well, the whole idea of preventing a pandemic often comes down to quarantining people who've been exposed, who are perfectly well, who are perfectly sick, perfectly healthy. But we have to do something for the good of society to protect them. And I don't think these nuanced kind of things are like a trademark issue we discussed or a child welfare issue. Those are things that can easily be looked at and read about. These are nuanced, very complicated medical issues where people don't understand even in the vaguest, I don't mean to be demeaning anyone, but they don't understand the nuances of these kind of things. And I really don't feel comfortable with an amendment having a judge or a court decide these things. I really think it ought to be a medical professional, whether it's under an oath or even a board of medical professionals. But I really do feel like it would be too nuanced for a non-medical person to make a decision. That's my opinion. Thank you very much.
Representative Buehler.
Thank you, Mr. Chair. Not to belabor the point, but didn't you state that it's already in statute that it goes to a judge? So it's not with a doctor today. So you would have to change the statute today. And even in absent of that, there is still no redress. So today, statute requires a judge, and we still have no redress for this young lady who was kicked out of school for 21 days. So, and I get the need for public safety. I am wholeheartedly in support of that, but we can't trample over everybody's individual rights for a sick person who's not, or a healthy person who's not sick. So, and I guess if there is an amendment, maybe that's where who makes the judgment call, whether it's a doctor or a judge. Today it's a judge, if I understand it correctly.
That's
Thank you, Mr.
correct.
Chair.
It's in section 201 of 65, and it's in section 129C of 65 that allows for the judge to hear these things. The same way a judge hears a medical malpractice case, judges often hear temporary injunctions, which means a really quick hearing on medical issues as well. It's not perfect. It's just the best system that we have.
Further Further discussion? Seeing none, thank you. Thank you very
Thank
much
you,
for
Chairman.
being here. Next, we have Ann Roberts. Ann, welcome to committee.
Ladies and gentlemen, thank you for allowing me to speak today. My name is Ann Roberts, and I am testifying in support of the intent of SB 29. Our recent experience with our local health departments might give you some insight into our concern about Chapter 65. On February 14th, just last month, my 14-year-old healthy daughter was identified by her school district as a potential close contact of another student with chickenpox. When the school district contacted us, they informed me that she was a close contact, instructed that she would not be allowed to come to school for 21 days or participate in her extracurriculars. At this point, I had still received zero contact from anybody at our local health department. After making several inquiries of the school district regarding this issue, I was finally contacted by a member of the Reno County Health Department a week after the initial order to not return to school. The health department personnel who contacted me stated that she didn't have any specifics on the contact tracing, as they didn't do it themselves. She told me that I was too concerned about the legalities in this case for my daughter and that she needed to be quarantined at home as she was considered a threat to public health. She told me to let her know by the end of the day if we were going to comply with their verbal order or if they needed to write a legal quarantine order. She indicated to me that most of the time people just complied. On Saturday, 12 days later, I was finally contacted by the Harvey County Health Department. Without doing any of their own contact tracing or investigation, the next morning, a member of the Harvey County Health Department arrived at our home and served a letter of quarantine to my minor daughter without her parents being home. We later discovered in Cora reports and documents that the Harvey County Sheriff refused to participate in this and serve the quarantine letter. The order stated that our healthy daughter was not allowed to leave our home for any reason. No exceptions, not even to seek medical attention if necessary. My daughter was never seen by a medical professional. She is not sick. In the meantime, my healthy 14-year-old daughter has missed 3 weeks of valuable instruction in her school. She is an honors level student and is a freshman at her high school. Some of the classes they just chose to exempt her out of, as they could not find a way for her to do those at home. Some of the classes, they had her do some online work. Some of them had some videos that they posted. Most of the time, these were the next day from when the assignments were due. They weren't clear. She was not able to get instruction and feedback from the teachers. She's never struggled in school her whole life, which is why she's in honors classes as a freshman. However, she is struggling. She failed her tests when she went back this week. She's now trying to make those up and figure out how to make all of this work up and how to understand everything so that she will be prepared when finals come. She was also exempted out of her short basketball season for the last 3 weeks that she had worked so hard for and missed the first part of softball season as well. This is time and participation in academics and extracurriculars that she will never get back. She also feels like that she was being told that she was in prison. I am here today to request that the committee do more to protect the rights of citizens and amend SB 29 to limit health department's recommendations to recommendations in education about illnesses, but not restrict the free movement of healthy citizens. The statutes that seem to guide and govern health departments are contradictory, like they were in our case, and nobody was able to help us or knew the right thing to do. This needs to be addressed so that citizens like my daughter are not irreparably harmed by confusing and conflicting statutes and rules that violate citizens' rights. Thank you for your time today, and I will stand for questions.
Very good, Ann. Thank you very much for that committee. Representative Blex.
Thank you, Mr. Chair, and thank you for your testimony and being here. The first person that decided that your daughter must go home, do you know if they had any medical background?
I do. She's a nurse.
Okay, thank you for that.
Committee further discussion. Representative Bueller.
So what I'm curious about with your situation is, how was it explained to you that your daughter was allegedly exposed? And did you apparently agree or disagree with that? Because that seems to be, and then someone took it upon their authority within existing regulations to just apply for the full measure of the law. So I'm
Which
curious.
was overturned by a judge, that quarantine was, but, because it was not found to be legal. But, so basically, we were told no information. When we were called, we weren't given exposure information, we weren't given how she was exposed, we weren't given any contact tracing information of any kind. And then when the health departments finally contacted us a week later, they also could not give any contact tracing information because they didn't perform it.
Thank you, Mr. Chair.
Committee further discussion. Representative Steens.
Thank you, Mr. Chair. You stated here that you said, I'll go get my daughter a vaccine today, and the principal was okay with that, even though he didn't think she was.
I didn't
I think
say
it was
that.
up here. You're Ann, right?
Uh-huh.
Okay. It says here, when the school district was contacted, instructed that she would come, and then it says the school district principal agreed that he didn't think my daughter was a threat to anyone, but here it says that, and that if I took her immediately to get a vaccine that day, she would have the option of returning to school immediately.
Okay.
So I'm just curious, I think I'm missing something here. Are these kids vaccinated or unvaccinated? I guess that's where I'm having a little trouble. So you're saying, like, if she did get the vaccine, that she could come back to school, but if she didn't have the vaccine, or if she didn't have a vaccine, that she was more contagious? Because, I mean, that seems kind of weird to me that they're saying, oh yeah, if you just go get a vaccine, that's fine, come on back.
Correct.
Okay. I'm just trying to understand that, because it seems kind of weird that all of a sudden you wouldn't be contagious anymore if you had the vaccine.
Exactly.
Thank you.
That's not how vaccines work.
Representative Berquist.
I'll try to be brief, sir. Ma'am, so was there any indication that there was a visible or otherwise clinical diagnosis of somebody having chickenpox in your community?
Not that I'm aware of.
Okay, and was there ever any indication that they thought by symptoms that she had that she might have chickenpox?
My daughter, no.
Okay,
Zero.
thanks.
Committee further discussion. Seeing none, thank you, Ann, for being here.
Yes, thank you.
Committee, I'll bring your attention to written-only proponent testimony, Melissa Campbell, Carrie Sue Vosberg, and Dale Enhart. Next, we have Randy Bowman as an opponent. Randy, welcome to committee.
Good afternoon, Mr. Chairman, members of the committee. Again, Randy Bowman. I'm the executive director of the Kansas Association of Local Health Departments. Privileged to be with you today on this topic. You have my written testimony in front of you, but we've brought up some different issues, so I might just deviate a little bit away from that if it satisfies the committee. And a lot to process, so we all need to process on it. But I think I would just try to remind the group, professionals have to make the best decision they can under the circumstances they're faced with. And you as lawmakers, we elect to represent us here in Topeka to make the best decision you can make and pass the best laws you humanly can to balance the rights of those who choose not to vaccinate and then kind of get wrapped up in situations like this sometimes, or can, and everybody else who doesn't want to get sick. And I'm sorry you have to make that call in situations like this, but you signed up to run for office, so thank you for doing that. But so it's a balancing act here, but whose rights and whose liberties are going to prevail in every circumstance? And there's been some other examples talked about today. So I would just say, let's not lose sight of that other side of the equation that's not going to testify to you today, that may have other facts the judge considered. I'll respect that the judge made the decision that's been described here. That's fine. But we do need to not lose sight of the other side of the equation, that if my child was in the classroom next to another child who might have been in the circumstances, what's my redress in that circumstance? So with that, I will be a resource to you now or later and just take questions if that's helpful.
Thank you very much, Randy.
Thank you.
Committee, Representative Opeza.
Thank you, Mr. Chair. So as I read this bill, it doesn't deal with quarantine, or am I wrong? It more deals with public gatherings?
I believe that's what it says.
Okay, I just wanted to make sure I was under the right assumption, not quarantine, but public gatherings. Okay, thank you.
Committee, further discussion. I have just one question. So
Absolutely.
if these folks would have been vaccinated, we would have never quarantined them? Is that what you're saying?
Most likely.
Really?
Vaccines protect us from these viruses. That's why they're so important. And we see measles in the media all over right now for that particular one. 95% of all of us getting the vaccine is the threshold. So it's important we all do our civic duty for one another to participate in the protections that medical science makes available to us.
So just to be clear, anybody else in that class that was vaccinated were not quarantined or anything like that? Is that what we're saying?
I do not know the facts of what has been described to you here today. But if you're vaccinated, you're protected. You would not need to be quarantined.
Thank you. Representative Howe.
Thank you, Chair. I'm going to perhaps open a little bit of a can of worms here, but it is true, is it not, that when you're vaccinated that you can have what I believe, if I remember the term correctly, it's been a while since I've studied this, but you can have what is called a breakthrough case, correct?
I'm not a medical professional, but I think you are correct that that can happen in a small percentage of cases.
So you can be vaccinated for the chickenpox and still get a light case of the chickenpox, or you could be vaccinated for the measles and still perhaps get a light case of the measles or something like that if you were exposed, or RSV or different things.
Yeah, thank you for the question. I know of nothing in this world that's 100%. Yeah.
Thank you.
Representative Droege.
Thank you, Mr. Chairman. I was just going to point out that vaccines aren't 100%. Some vaccines are better than others. The best I think I've ever heard of is 98%. But it also depends on what stage your immune system is in. If your immune system is not responding, your vaccination did no good. And often when you give a vaccination, you need to give a repeat vaccination to re-stimulate the immune system, because you're trying to stimulate the T cells to remember this insult, so that in the future, if they get exposed to this insult, that's a little too far in the weeds. I'm telling you that vaccines are not 100%, and that's one of my problems is, so if you just say, well, they've been vaccinated, so they're protected, well, that's not always the case. I mean, vaccines do a good job, but that you can't just say, well, if they'd been vaccinated, we wouldn't have had to worry about it. Well, that's not true.
Thank you for that. Committee, further discussion. Very good. Thank you, Randy.
Thank you all.
Okay, committee, I'll bring your attention to written-only opponent testimony, and I'm not going to bother to take the time. You can read through the list. There's an extensive list here of opponents. And so with that, we will close the hearing on Senate Bill 29, and we will open the hearing on Senate Bill 67. Carly, will you give us an overview? Thank you.
Thank you, Mr. Chair. Committee Senate substitute for Senate Bill 67 authorizes registered nurse anesthetists to prescribe, procure, and administer drugs consistent with the nurse's education and qualifications. Section 1 amends KSA 65-1158 to state that a registered nurse anesthetist may prescribe durable medical equipment and prescribe, procure, and administer any drug consistent with such nurse's education and qualifications. A registered nurse anesthetist would only be permitted to prescribe, procure, and administer anesthetic agents as authorized by subsection A. Subsection B requires that any controlled substance that would be prescribed, procured, or administered in accordance with the Uniform Controlled Substances Act. Section 1 also prohibits a nurse anesthetist from performing or inducing an abortion or prescribe, procure, or administer drugs for an abortion. It also requires that a prescription order include the name, address, and telephone number of the registered nurse anesthetist, and that a nurse anesthetist shall not dispense drugs but may request, receive, and sign for professional samples. Finally, for a nurse anesthetist to have the ability to prescribe controlled substances, they must register with the Federal Drug Enforcement Administration and comply with Federal Drug Enforcement Administration requirements related to controlled substances. The bill passed the Senate by a vote of 36-4 and would go into effect on July 1st, 2025 upon publication in the statute book.
Very good. Thank you for that, Carly. Committee questions of Carly. Representative Opeza.
Thank you, Mr. Chair. Carly, I just had a quick clarifying question. So as I read it on page 1, line 27, and then you kind of go down to the subsection A, in one note you can say that they can prescribe, and then the next they shall not. On line 30, what am I missing?
Mr. Chair, so line 27 in that subsection, except as permitted by subsection A, a registered nurse anesthetist shall not prescribe, procure, or administer an anesthetic agent. So I think the difference is between other controlled substances and the anesthetic agent, except as provided above in subsection A.
So as I'm interpreting that, I'm sorry, Mr. Chair. As I'm interpreting that, do they lose the ability to prescribe anesthetic in which they were trained for?
Mr. Chair, Representative, no, because in subsection A, it reads, upon the order of a physician or dentist requesting anesthesia or anesthesia care, each registered nurse anesthetist shall be authorized to, and then it provides a list of what they are authorized to do.
Okay, thank you. Thank you, Mr. Chair.
Committee, further questions of Carly? Seeing none, thank you very much. Next, we have proponent testimony from William Wilk. William, welcome to committee.
Good morning, afternoon, Mr. Chairman, members of the committee. I'm sorry for that typo in my testimony, Mr. Chairman. My name is William Wilk, Senior Director of Government Affairs for the Kansas Chamber of Commerce, and we appreciate the opportunity to provide proponent testimony for substitute for Senate Bill 67, which authorizes registered nurse anesthetists to prescribe, procure, and administer drugs. Substitute for Senate Bill 67 would remove government-imposed barriers that increase the regulatory burden and restrict trained healthcare professionals from performing their work to the full extent of their training. Healthcare, like all industries, face a workforce shortage. Those challenges are made worse by unnecessary state laws and regulation restricting access to affordable, high-quality healthcare for Kansans. Whether we are talking about APRNs, dentists, or CRNAs, we should ensure that state laws does its job to protect patients without limiting competition in the marketplace. Those two philosophies can coexist and are not mutually exclusive. The Kansas Chamber will continue to advocate for policies that reduce government barriers on our healthcare professionals without sacrificing any of the safety concerns when it comes to the regulation of health-related issues and practices. We should allow our health professionals to practice what they have learned and been trained to do through the technological advancements in healthcare. Removing these government barriers will increase access to healthcare professionals, reducing current wait times to receive diagnoses and treatments for Kansans across the state. We would encourage the committee to continue to evaluating state policies and removing government-created regulatory barriers where possible. With that, thank you for the opportunity to testify this afternoon, Mr. Chairman, and I'm happy to stand for questions.
Thank you, Will. Committee questions, Will. Seeing none, thank you very much. Next, we have Kelly Hutton Gordon. Kelly, welcome to committee.
Thank you so much. Thank you, Mr. Chairman and honorable members of this committee. My name is Kelly Hutton Gordon, and I have been a practicing CRNA for 25 years here in Kansas. It is my pleasure to submit the following testimony on behalf of over 900 members and fellow CRNAs in the Kansas Association of Nurses Anesthetists, of which I am now president-elect. I served in the United States Army. I was attached to a head and neck trauma unit that I was ready available to provide as an independent provider on this forward surgical team. Following my tenure in the Army, I also provided independent practice to Dwight D. Eisenhower, Leavenworth, Kansas, for 8 years. I currently own and operate Ethos Anesthesia Services, and we provide exclusive anesthesia contracts to facilities all over Kansas and Missouri, as well as intermittent staffing needs. I am very well versed in the anesthesia needs of Kansas. I come before you today to speak in support of the modernization of nursing statutes in Kansas to allow CRNAs to continue to provide high-quality patient care without unnecessary barriers. CANA and its 900-plus members respectfully request that you support SB 67 for your Kansas constituents. Those that have currently been hearing this request for modernization have also heard previously. CRNAs have been practicing in the U.S. for well over 150 years. CRNAs provide annually over 50 million anesthetics to patients in the USA. Multiple studies have been conducted providing a solo CRNA is the most cost-effective anesthesia approach for any facility, therefore saving money to the healthcare system and ultimately the state and the Kansas constituents. Multiple studies have been conducted that have proven, despite what opposition states, that there is no difference in safety between the anesthesia care team model or a solo CRNA providing anesthesia, and I'm happy to present these studies if requested. The Federal Trade Commission has weighed in multiple times, stating as recently as 2019, and I quote, "Consistent with patient safety, however, we have urged regulators and legislators to consider the benefits that more competition from independent APRNs, including CRNAs, might provide, especially benefits to patients. If APRNs are better able to practice to the full extent of their education, training, and abilities, and if institutional healthcare providers are better able to deploy APRNs as needed, healthcare consumers, patients are likely to benefit from improved access to healthcare, lower costs, and additional innovation," unquote. In 2012, Medicare published a final rule authorizing direct reimbursement of CRNAs for chronic pain management services. This action confirms the fact that the federal government recognizes CRNAs as qualified pain management providers. The current Kansas statute, KSA 65-1158, regulates CRNA practice states, quote, "Upon the order of a physician or dentist requesting anesthesia or analgesia care, each registered nurse anesthetist shall be authorized to," which is followed by an outline of tasks that we are able to perform. This verbiage directly limits our availability to patients as it restricts that we can only collaborate with a physician or a dentist. In many facilities across Kansas, providers covering the emergency room are nurse practitioners or physician assistants. CRNAs currently provide 85% of solo practice across the state of Kansas in these rural hospitals. These providers in a trauma or emergent situation cannot legally collaborate with CRNAs for any procedures, including establishing an emergent airway, doing a lumbar puncture for possible meningitis, both of which are life-threatening emergencies. So I ask you a very personal question. If you or a loved one are driving across the state of Kansas, get in a car wreck, need an emergency intubation, do you want that intubation to be performed by a CRNA who does this on a daily basis, or do you want that intubation or that lumbar puncture done by a nurse practitioner or a physician assistant who maybe only does that one time a year? This is a very simple question, and one that if it were myself or my child, I would readily answer because I've done these life-saving remedies every single day of my career. The healthcare arena is and has been changing for years here in Kansas and as well as across the United States by professionals whose services provide overall very safe, high-quality, and cost-effective outcomes for millions of Americans. CRNAs do and have met this criteria year after year across the nation and in Kansas. Our statute verbiage is archaic and needs to be changed in order for us to meet our patients' needs without fear of legal recourse, but to allow us to practice at the full scope and training that we have received. The Kansas Association of Nurse Anesthetists appreciates the efforts of the committee in its willingness to support access to high-quality health care in Kansas and urges you to support SB 67. Thank you very much for your time. I'm available for questions.
Thank you. Committee questions? Seeing none, thank you very much for being here.
Thank you so much.
Next, we have Jason Worth. Is he
not available? He has acute shingles.
Okay. Okay. Committee, I'll bring your attention to written proponent testimony. You can take a look at that, and we'll move on to opponents. And the next opponent we have is Rochelle Columbo, no stranger to this committee.
Good
Rochelle?
afternoon, Mr. Chairman, members of the committee. I am Rochelle Columbo. I'm the Executive Director of the Kansas Medical Society, and I appreciate the opportunity to be before you in opposition to Senate Bill 67. I want to address a couple of things, provide a little bit of history about how we got here, and maybe respond to some of the comments that were made by the proponents. The bill, as originally drafted, would have completely undone the CRNA Practice Act, which is different than the Nurse Practice Act. Many of you on this committee will remember that in 2022, the legislature opted to allow APRNs to prescribe and to order durable medical equipment. Senate Bill 67 was then brought the next year, even though it was a different bill, but the same contents of the bill, because the CRNAs had been exempted from the Nurse Practice Act. They have their own, and they weren't included in the changes made in 2022. And at that time, they said, we just want to be able to do what our other APRN nurse counterparts can do, which is to prescribe. The bill in its original form would have allowed far more than that, as you just heard from a previous conferee. And I think she explained some of the things they want to be able to do, which are very much the practice of medicine, as is prescribing, which is why we oppose that. We believe that training and education matter. CRNAs are excellently trained, as are all APRNs, but the training is different. And that training does result in differences in quality and safety for patients. And there shouldn't be different standards for different providers if they're doing the same service. With respect to the bill as it's been amended by the Senate, it has now been limited to just prescribing and the ordering of durable medical equipment, which is what the APRNs passed in 2022. I would say as an aside that since the passage of that bill, there are many APRNs who are practicing independently that are not having a collaborative practice agreement at all, maybe have their own clinics and places where they're offering much more than prescribing and ordering durable medical equipment. It's a known problem. It's existing. There are complaints, and likely it will result in legal action at some point, and that's unfortunate. So we really feel that there needs to be clarity. There needs to be appropriate regulation that protects patients. As the bill has been amended, I think, the legislature has already deemed that they believe it's appropriate for non-physicians to prescribe, and this would be equivalent to that. So we don't support that, but we understand that the legislature has awarded that privilege to other classes of APRNs, and it's understandable that CRNAs would want to have the same privileges as the other APRN counterparts. So with that, I'd be happy to stand for questions.
Thank you, Rochelle. Committee questions. Representative Bryce.
Thank you, Mr. Chairman. Thank you, Rochelle. Just to be clear, what you were saying, there are currently CRNAs who are basically practicing in solo practices, prescribing, diagnosing, as in a clinical situation?
No, APRNs who are not CRNAs. And again, CRNAs were exempted from that, and there are APRNs who are in general practice that are opening independent clinics, and we know that there are many of them doing lasers, there are doing things far beyond what was granted by the legislature. And so we have concerns. We don't think this is the best way to move forward, but it is the purview of the legislature to make that decision, and we do appreciate that the bill has been limited to only what was passed for the APRNs.
Representative Blex.
Thank you, Mr. Chair, and thank you. I appreciate you standing up for health care and safety. I support that. However, in the case with the APRNs, we were told that there would be blood up to a horse's bridle in the street. That didn't happen. It won't happen. And basically prescriptive authority. I appreciate this bill being amended to where it's at. I think it's a little more restrictive. But, I talked to a dentist that's right almost the edge of my district. Because the CRNAs do not have a DEA number, they basically cannot order the thing. So a dentist has to order it, which is not an anesthesiologist, and then they administer it. And he said, I really don't have a clue how they do that. But so they're doing it every day. So while it's not under supervision, and I go back to the supervision that the general public appears that we have, they think that a physician is directly looking over the shoulder of a APRN or CRNA, and that don't even happen. That ain't even close to being right. in most cases, and particularly with the APRNs, there was a written protocol signed. You wrote a check to them every month and you never saw them. And they cashed the check. And I guess I've always been an advocate of allowing people to practice within the scope of their education and their license. And certainly I see this as just being a natural because they're already doing it, and why have somebody else order it? But I do appreciate you. I know you stand up for public safety, and I want that too. So that's kind of where I'm at.
Representative Steens.
Thank you, Mr. Chair. So just for clarification myself, our previous conferee was saying, like, if you're in an emergency situation, so let's just say a rural hospital, the CRNAs cannot intubate. Am I correct? Am I understanding that correctly? So an APRN or a physician's assistant can, but a CRNA cannot do that. Is that correct?
Well, I can't speak exactly to that. I thought that was a little bit confusing. I guess I'll try to answer as best as I know how. CRNAs work quasi-independently right now, and in many rural areas, it's true that they are the sole anesthesia provider, but they have to work upon a physician or a dentist order to order anesthesia. And so that simply means that they can't diagnose, initiate treatment, and perform anesthesia on their own. That is the practice of medicine. And so the way that works is they have a collaborative practice agreement with a physician who those can be structured in any number of ways, but it does provide, Representative Blex is correct, it is not over-the-shoulder supervision. It's probably not with an anesthesiologist because there aren't very many in those rural areas, but any physician can supervise a CRNA. It's not limited, so it could be the surgeon is the one that has to make that order, or the dentist. But that's the way it works currently.
So they would have to have an order or have someone over them.
They have someone that they have, yes, a working relationship with that then determines what things they are doing in those environments. And a physician has partial responsibility for that in terms of liability.
Thank you.
Committee, further questions? I just have one, Rochelle. How many APRNs have developed a standalone practice since we passed the APRN bill?
I couldn't tell you the answer to that. I mean, I have no idea. I don't know how that would be determined exactly. But there are many. I mean, yeah.
Many is a pretty...
I mean, I think I've seen about 12 in Topeka since the passage of that bill. So there's a lot. A lot of them are focused on weight loss or medical, like aesthetics and things like that. But that does go beyond prescribing.
Okay. Very good. Thank you for that. Committee, further questions? Very good. Thank you. Okay, written only opponent of Joseph Nicholas, private citizen, neutral, written only from Rashane Hamby. Okay, with that, committee, we're going to close the hearing on Senate Bill 67. We'll open the hearing on Senate Bill 250. Carly?
Thank you, Mr. Chair. Committee, Senate Bill 250, as introduced, enacts the Right to Try for Individualized Treatments Act to permit a manufacturer to make an individualized investigative treatment available to a requesting patient. Subsection A defines an eligible patient as an individual with a life-threatening or severely debilitating illness who has considered all other treatment options currently approved by the U.S. Food and Drug Administration and has received a recommendation from their physician for an individualized investigative treatment. This subsection also provides definitions for other terms used in the bill, such as life-threatening or severely debilitating illness, and written and informed consent. Subsection B states that an eligible manufacturer may make available an individualized investigative treatment, but that the Act does not require a manufacturer to make such treatment available. It also allows such manufacturer to provide treatment to a patient without receiving compensation or require that an eligible patient pay the cost of the investigational treatment. Subsection C states that this Act shall not expand the coverage required of an insurer under the Insurance Code of Kansas. Subsection D allows a health plan, third-party administrator, or governmental agency to provide coverage for the cost of investigational treatment and states that this act does not require any governmental agency to pay for the costs associated with an investigational treatment or a hospital or facility to provide new or additional services unless approved by such hospital or facility. Subsection E states that the patient receiving investigational should the patient receiving investigational treatment die during such treatment, then the patient's heirs would not be liable for any outstanding debt associated with the treatment. Subsection F provides that a licensing board shall not revoke, fail to renew, suspend, or take any disciplinary action against a healthcare provider's license based solely on such healthcare provider's recommendations to an eligible patient regarding access or treatment with an investigational treatment. Subsection G states that an entity responsible for Medicare certification shall not take action against a healthcare provider's Medicare certification based solely on such healthcare provider's recommendation that a patient have access to an investigational treatment. Subsection H requires that an official, employee, or agent of the state shall not block or attempt to block an eligible patient's access to investigational treatment. Subsection I states that this act does not create a private cause of action against a manufacturer of an investigational treatment or any other person or entity involved in the care of an eligible patient using such investigational treatment. Subsection J provides that the act shall not affect any mandatory health care coverage for participation in clinical trials under the Kansas Insurance Code. Subsection K names the act as the Right to Try for Individualized Treatments Act. The bill passed the Senate by a vote of 36-4 and would go into effect on July 1st, 2025 upon publication in the statute book.
Very good, Carly. Thank you for that. Representative Orpeza.
Thank you, Mr. Chair. I have a couple of questions. So as I read this bill, does this bypass the ethical safeguards like a institutional review board that they currently have like at academic centers?
Mr. Chair, Representative, I think that requires a little bit of research. I could look into that for you.
Okay. I have another question. And then you talked about civil action could not be taken against the healthcare provider recommendations. What about administrators, as in nurses? Because we talk about biologics.
It does say, Mr. Chair, Representative, or against any other person or entity involved in the care of such patient.
Okay, thank you. Thank you, Mr. Chair.
Representative Bryce.
Thank you, Mr. Chair. Hey, Carly. Did you have a definition of investigational treatment?
Mr. Chair, Representative, yes, that would be sub A, subsection 2 on line 23. There's a definition for individualized investigational treatment. Would you like the definition, or?
Let me just ask one other thing, if I could then. By definition, an investigational treatment is being investigated and is being used for treatment. So why can't I, if I have a terminal disease, join a current scientific study? What does this what extra benefit is this from me just going to KU Medical Center and joining an investigational study on something that's not approved yet, that's already available for me to do? Does this open the doors to more? Thank you.
Mr. Chair, Representative, that might be a question for a conferee.
Okay.
Representative Ruiz.
Thank you, Mr. Chair. Carly, it's under that investigational treatment, who calls it that? You know, so let's say, for instance, a physician has ordered a certain kind of treatment, and whatever insurance that patient has right now is that treatment is denied because the insurance is saying that's investigational.
Mr. Chair, Representative, I am unsure on who is calling it this. So again, a conferee may be able to answer that.
Thank you.
Very good. Committee, further questions? Seeing none, thank you, Carly, for that. Okay, maybe your questions can be answered by Dr. Patrick Bailey. He's virtual. Can you hear us?
Sir, can you hear me?
Yes, we can. Welcome to committee.
Thank you, Chairman Carpenter, Vice Chair Bryce, Ranking Member Ruiz, and members of the committee. I'm Dr. Patrick Bailey. I'm Director for Healthcare Policy at the Goldwater Institute in Phoenix. I appreciate the opportunity to join you for purposes of offering public comments on Senate Bill 250. This legislation is vital for preserving the right to try to save one's own life without being required to plead with the federal government for permission to do so. SB 250 applies to novel, bespoke treatment for rare diseases that are custom made and based on one's own genetic profile. This legislation is made necessary because the FDA's regulatory scheme has simply not kept pace with advancements in medicine. The current federal drug approval system simply did not contemplate and is not designed to effectively or efficiently consider treatments based on individual genetic profiles. Kansas has an important opportunity to lead the nation in resolving this issue for patients with rare diseases and thereby potentially saving lives by enacting the Right to Try for Individualized Treatments Act. The original Right to Try gave patients the right to seek treatments that have passed the FDA's safety trials, but were still undergoing trials to determine their efficacy before receiving final approval. That bill passed in 41 states, and ultimately in 2018, Congress passed the legislation and President Trump signed it into law. Right to Try has made a dramatic impact on patients' lives. However, because of continued medical advancements, particularly in genomic medicine, Right to Try needs to be updated and modernized. Bespoke treatments based on one's specific DNA profile are not covered by the original Right to Try. Thus, this legislation is necessary. Right to Try for individualized treatments does not change in any way the original Right to Try. Rather, it would create a new, safe, and physician-directed pathway for patients with ultra-rare, life-threatening, or debilitating diseases for whom there is no other treatment option available and who could potentially benefit from an individualized treatment that is designed and manufactured based on their unique genetic profile. Pioneering medical innovations now make it possible to create individualized treatments based on patients' unique genetic information. However, the clinical trial evaluation system, which was created in the 1960s, was designed for evaluating drugs that would be used to treat large populations. Hence, these individualized treatments are still subject to the same clinical trial process as medications intended for thousands of patients. The Right to Try for Individualized Treatments Act allows for these advancements in genomic medicine and the innovations that provide the means to create bespoke medical treatment based on one's unique genetic DNA profile. Right to Try for Individualized Treatments is already law in Arizona, Nevada, Louisiana, Arkansas, Mississippi, North Carolina, Maryland, and as of this week is also passed in Tennessee and awaits the signature of the governor. It's being considered in numerous other states this legislative season. Individualized bespoke treatments are being pioneered domestically and abroad, but unfortunately, patients in the U.S. often must travel to receive these potentially life-saving therapies. This is unnecessary. Kansas can be a leader in getting the right treatment to the right patient at the right time. I will close by saying it's important to note that removing the federal bureaucratic process that hinders these treatment options requires no additional taxpayer investment. It can be assuredly be achieved in a manner that addresses patient safety concerns and preserves informed consent. Thank you for your time and consideration.
Very good. Thank you, Doctor, for that. I think we do have a few questions here. Representative Bryce.
Yes, thank you, Mr. Chairman, and thank you, Dr. Bailey. Just a question I had was, why would someone enter a treatment in the right to try program rather than enter a clinical study that could potentially benefit many, many people by enrolling in a study where the results could be used in the future. Thank you.
This legislation is directed at treatments that are individualized to one person based on their DNA sequence. And therefore, what's going to be a correct treatment for me based on my DNA sequence is probably not going to be right for anybody else.
If I could follow up, yes, sir. But there are many, many people doing this type of treatment, which there could be a clinical trial with this group of people to see the efficacy and safety. We kind of lose that data on efficacy and safety of the whole group if we just have an individual. Is that not true?
These treatments are manufactured specifically based on an individual's DNA. So because they're manufactured for an individual's DNA, their applicability to someone else with different DNA is not going to be not going to accomplish the purpose that you're alluding to.
Maybe I'm not expressing myself well enough. I apologize. If there are many people using this modality, that could be a clinical trial to see efficacy and safety. Or has this already been done? And efficacy and safety has been proven, and so that's not an issue?
I think the best way to answer your question is to go back and refer to the original right to try. And that was needed because you had drugs that were directed at larger populations of people who had a similar condition. And so the drug was developed for a large population. And the original right to try gave access to those drugs that had passed the safety trials, but not completed the efficacy trials. These new drugs that are these new treatments that are based on individual DNA sequence will never even be able to get to the numbers to get to the threshold to go through the safety trials, let alone the efficacy trials. So because the FDA clinical trial process has not been updated since the 60s, we need to provide a pathway for somebody to receive a drug that is manufactured specifically for them, not something that is manufactured for the broader masses with a disease.
Thank you, Dr. Bailey. Let me just briefly try to attack this from another angle. Has there been any morbidity or mortality associated with this treatment modality?
I don't have any definitive data on that. I can tell you that from the original right to try, that we have a limited amount of data on the number of drugs that were used, the number of doses that were used. What we do know is that the original right to try has made a difference in people's lives, and glioblastoma is a classic example. Again, it's a different type of drug, but it was a drug that was being able to administer based on the right to try, and that's taken their mean survival rate from about 8 months to about 22 months. So what we're saying here is if you've got a life-threatening or debilitating disease and you've considered all other treatment options that are out there, and there's a manufacturer who can provide you with a treatment that is specific to your DNA sequence, then you should have the right to get that. We know of a family here in Arizona that had daughters with one of these diseases that had to go all the way to Italy during the pandemic to get treatment. And by the time they got there, unfortunately, one of their daughters had progressed so far that she was not eligible for the treatment, and that daughter is now in hospice care. On the other hand, the younger daughter had not progressed so far, received this treatment in Italy and is now doing quite well. But again, these are very rare diseases that are based on individual DNA sequences and not something that are going to be very common by definition, nor is a drug for one patient who's got the disease necessarily going to be applicable to another patient who's got the disease because it's based on a different DNA profile and sequence.
Thank you, sir. Thank you, Mr. Chair.
Thank you, Doctor. Representative Reese.
Doctor, so would a spine stimulator fall in this category? Because that is often looked at as an investigational treatment.
I'm sorry, would it apply to what, ma'am?
A spine stimulator?
This drug
It's a
applies
device.
to.
I see in the bill that devices are included.
If the device is specific to your DNA profile, then yes, it would be applicable. That is the narrowing of this, is that whatever the drug, the treatment, the device is, has to be specific to your particular DNA profile.
Okay, thank you. I'm going to ask you a second question here. What is the cost of this? I can only imagine very few people would be able to afford this.
I think that's a very accurate assessment that this is going to be very expensive, and that's why it's important that the bill includes that for everybody involved, it is purely voluntary. A patient with their doctor's approval can request the treatment from a manufacturer. The manufacturer has the option to provide this or not provide this. They cannot make a profit on this. They can recoup their direct costs, but they cannot make a profit on this. And so instead of limiting, the availability of these drugs to just the very wealthy, what this does is it opens it up for everyone to come to the conclusion that they could benefit from this treatment, and then to go through the process under physician guidance to approach a manufacturer and then to find a facility that has federal-wide assurance where they can receive this treatment. But again, this is all voluntary and just allows the patient to seek a treatment to save their own life if they have a rare and debilitating disease.
Thank you.
Representative Bueller.
Thank you, Mr. Chair. And I think the question, I want to pose an example to you. So I have a relative who's got this person is going to lose they're a sighted person, they're going to go blind before the end of their life. We know that, and it's related to the individual's DNA and genetic sequencing, as you mentioned. We know that there are treatments over in Europe somewhere, I don't know if it's Finland or Denmark. The FDA is currently working on trials in the United States, but there's nothing proved here, although I think it's the University of Iowa healthcare system has an eye doctor that has an interest. So in this right to try scenario, would the European treatments potentially be available then at the University of Iowa or somewhere else in the United States who's willing to try that? Is that what I'm understanding?
So I think that if I'm understanding your hypothetical correctly, if this drug that's in, let's say Finland, wherever it is in Europe, if the doctor in the United States can obtain from the manufacturer that treatment, then this legislation would enable the patient to receive it with the doctor's affirmation that he believes that there's nothing else that is on the market currently that can treat it and that this might help. And then the manufacturer has the option whether or not to provide it, and the institution that has federal-wide assurance would then, if they agree to participate in the administration, then yes, the scenario that you propose would preclude someone having to travel to Finland to receive that treatment.
Thank you. Thank you, Mr. Chair.
Any further questions? Representative Steens.
Thank you, Mr. Chair. Just to follow up about the insurance. So if this is passed with and becomes law for right to try, I read in here, it says that the third-party administrator or governmental agency could provide coverage. So am I understanding now the insurance companies, I'm assuming, don't pay for if it's investigative, or they would still have the right to deny or pay for the cost?
That is correct. They would have the right to pay for it or deny it. Nothing in here makes it mandatory for the insurance or third-party payer.
Okay, thank you.
Any further questions? Seeing none, thank you very much, Doctor, for your time today.
My pleasure.
Okay, committee. That concludes the hearing. Oh, I'm sorry. We do have a neutral. Susan Goff, sorry about that. I about skipped over you. And you've been sitting there so patiently, so.
It was all been very interesting stuff today.
Yeah, thank you very much for hearing that.
No worries, I'll try to be quick for you.
All right.
Good afternoon, Chair Carpenter and honorable committee members. I am Susan Guile, Executive Director of the Kansas State Board of Healing Arts. Thank you for allowing me to be here today. I just want to take a few moments to follow up on my written testimony. As stated in my written testimony, the intent of this bill, Senate Bill 250, is really incredible and needed for those that are in these dire circumstances. And I certainly don't want to be the black cloud of this bill, but the mission of my agency is public protection. So sadly, I do have to think about those who might potentially be unscrupulous and try to take advantage of this bill. And I have to make sure that if and when they do, my agency would still have the ability to bring those bad actors to account. I also want to be sure that the bill is absolutely clear, and that even with the very best intended providers, that those in some of their darkest days are making the most informed decisions they can. And to that end, I think there are some opportunities to potentially tighten the bill up just a little bit. So I'll just start off. Section 1A5 talks about informed consent and the consent being signed by a witness. I think it is extremely important that the witness not be in any way affiliated with the physician or the product marketers. This needs to be a person who only has the patient's best interest in mind and who can truly assess whether the patient is fully understanding what they're signing. Second, Section 1B requires that the patient provide an attestation that the patient concurs with the patient's physician that all currently approved and conventionally recognized treatments are unlikely to prolong the patient's life. This is really requiring something well beyond the means and abilities of most patients, and certainly beyond most patients who qualify for these treatments. The intent of this, I think, or should be covered in the informed consent, where they should be explaining the potential benefits and consequences of the investigatory treatment. If more than that is needed, I think potentially a second medical opinion would be in order. But asking a patient to concur about complex medical opinions, I believe, is just simply unacceptable. The final issue I would like to see clarified and to be sure is made perfectly clear to these patients is that of payment, which is actually addressed in two sections, Sections 1A5G and Section C. As written, it appears that the patient is agreeing that they are liable for all expenses and that this liability extends to their estate. The second states that if the patient dies during treatment, their heirs are not liable for the payments. I think it has to be clear that while the heirs are not responsible for the payments, their estate is attached, so that if that patient dies, while their heirs may not have to make payments, their house may be attached. Their retirement accounts may be attached, et cetera. So there's potential for a huge financial liability. This has to be abundantly clear to these folks. If this is fully understood and recognized, this may result in a different decision by some of these patients, or at very least, we have to know that they're making a fully informed decision. So if all of these things are clarified, I think it makes a better bill, better patient care, and also better protects the patients from those potentially unscrupulous. So I am happy to stand for questions at the appropriate time.
Very good. Thank you for that. Committee questions. Representative Droege.
Thank you, Mr. Chairman. On that, not being responsible for the treatment on death, what about other deaths? What if they get hit by a car in a car wreck?
As I understand the bill, and I would certainly look to the reviser, it just says if they died during treatment. So it doesn't say as a result of the treatment or because of the treatment, it just says during treatment. So that's.
Thank you.
Committee, further discussion. Very good. Thank you.
Thank you.
Thank you very much for being here.
Well, thank you for your time.
Okay, committee, I think there are nobody else to testify for that, so I'll close the hearing on Senate Bill 250. And just as a matter of discussion, committee, we will probably work these bills on Tuesday. So amendments that you have, for instance, just what was mentioned here, get with Carly and Jenna. And also on Senate Bill 29. And I don't know about anything on 67, but if you do have some that we're not aware of, certainly get with Carly and see if we can't get those amendments. I could postpone it if you had amendments that were not available. We could make an exception and do it on Wednesday potentially if the amendments weren't ready, kind of up to Carly and Jenna. So keep us informed about what's going on. And committee, thank you so much for your patience this week and your attention. And I know it was a busy week, but I think next week you'll understand that when we kind of have a light week that it was good to get it out of the way this week. But anyway, with that, have a great weekend, and we're adjourned.